How can you use Freeman-on-the-Land arguments to earn yourself £500,000 a month? It is possible, and let me explain how. Our story starts with a company called Matrix Freedom, and they put out a series of adverts where they explain to people how, by using these secret, simple formulas that lawyers hate, you don't have to pay your mortgage. And if you have paid your mortgage, you can get all your money back. And, you know, they quote lots of statutes and things. They say the Negotiable Instruments Act of 1861, the International Trade Bills of Exchange Act 1872, the Fair Credit Reporting Act, public law. The trouble is, none of these are actually UK cases. But how did this scheme work? Well, basically, you signed up to their service and they gave you access to various documents that you basically signed. You effectively made them the trustee. You assigned your right of action to them, although you purported to do, but then, as we'll see, it didn't quite work like that. But you signed up to this scheme, they gave you some paperwork to fill out, and they actually brought this to court. And it was a guy called Ian Smart, he's the director of the company, and he brought a claim in his own name, and also on behalf of 200 test claimants against the mortgage companies. What I find quite interesting is that it actually says in the head notes, this is a bit of judicial snark, it says Ian Clifford Stamp and others as set out in the above claim forms against Lloyds Bank PLC, incorrectly sued as Lloyds Bank UK PLC, and Bank of Scotland PLC, incorrectly sued as Halifax PLC. So a little bit of a snark there for getting that wrong. But as it happened, Mr. Smart himself did not turn up to this case. He claimed to be across the seas, and that wasn't actually sort of Freeman-on-the-Land sort of, you know, verbiage. He actually was. He lives in Indonesia now. But two poor people did go along, and the judge went through the case and said, you know, there's just nothing in this. It's just random ramblings. They were highly suspicious of the fact that all 200 claim forms were identical, even though obviously the position of the various claimants would not have been. And when they actually asked, the two guys who turned up and said, you know, is this your claim? And they said, well, no, we basically, we've just been sent along here. We just got told what to do. And the judge said, well, you know, you have signed a statement of truth here saying this is all your own words and this is all your own case. And they said, well, no, we just, you know, we just let them deal with it. Perhaps unsurprisingly, the claims were struck out. And the judge actually said, he said, this isn't just, you know, for the benefit of the defendants, this is a mercy to the claimants before they get embroiled in yet more pointless litigation, because of course, you know, they had to pay the costs of the failed claim. But they also, you know, the court made a totally without merit certification on these claims. You know, said these are absolutely nonsense against Mr. Smart. So they said, you know, that's your one shot across the bows. Now, apparently he'd also brought a claim against the HMRC, against the revenue, for £100,000 along similar things, you know, trying to get tax back. And that was also struck out, £100,000, you know, and another totally without merit. So they were struck out. But then like an organisation, Open Democracy, they did a big expose on this, because their argument was, you know, this is effectively defrauding people. It transpired that there is a fee for their services, and their fee is 10% of any sums recovered. And that fee has to be paid up front, and there's a minimum of £3,000. So you went to their website, and when you applied, you entered, there was a little calculator there where you would sort of say, this is how much my mortgage is, this is how much I've paid, you know, over the years or whatever. And it would come up with a figure and say, you are entitled to £274,000 back. So yours £2,740, round it up, that's £3,000. And it turned out, because, you know, this is a proper company, apparently employs 40 people on a full-time basis, and some people managed to get hold of some internal management Zoom meetings where it's fairly clear they knew that this was perhaps not not the best way of going about things. They actually said we need to avoid going to court on this, because if people, if this goes to court, it'll all be knocked out. But it turned out that on a good month, when they were going through the figures, they were earning £500,000 a month off people signing up to these schemes. When this was revealed, Mr. Smart brought another case. He brought a defamation claim against Open Democracy. Again, though, that was struck out, and it was struck out on the basis that he didn't really claim defamation. He just interestingly, they also putting their money where their mouth is. He didn't run a proper defamation claim, a properly pleaded one. He just basically quoted lots of like Magna Carta and Bill of Rights and no law is valid after 1973, and I did not consent to be defamed. Therefore, you owe me all this money. Perhaps, again, unsurprisingly, that too was struck out. And he got onto that totally without merit. Also, in the original things, they also said it was a contempt of court to bring this litigation, because litigating is a restricted activity. You have to be licensed to do it. Solicitors are generally licensed. Barristers generally aren't, although some of us have done like some extra training, so we actually are allowed to do litigation. But they were litigating unlawfully. That is actually a criminal offence to do so. So that also didn't go down very well with the courts. But yeah, what will happen next? Well, apparently some of the people now who signed up to these services and are very out of pocket, because presumably some of these people, they've lost the court costs. Some of them will no doubt have been in danger of like repossession now, because they cancelled their direct debits on, they were told, oh, stop paying your mortgage, so people are chasing. So people have lost out, so apparently some of the people are now trying to sue this company. It'll be interesting to see what happens. But the courts have also made a civil restraint order against this Mr. Smart, saying, look, you've had 3 totally without merit strikes. We're going to take the step of banning you from bringing in more claims. And what's interesting, actually, normally the way that works is if you wish to bring a claim and you've got one of these sort of civil restraint orders, you have to apply for leave to the court. So you say, I want to bring a claim, this is what the claim is, and the court will have a look and go, either that's nonsense, I'm not letting you do it, or okay, fair enough, I'm not saying you'll win, but that's an arguable claim, off you go. But in this particular case, they've adopted the Canadian approach, which is anything he submits is automatically struck out. If he does anything that's got any sniff of a Freeman-on-the-Land language, they said it will automatically be struck out now. They're not even giving him the chance to actually argue that he should be allowed to bring the claims. They're just saying, from now on, you are pretty much debarred from the court system. Theoretically, he could sort of, argue and try and overturn that and say, you can't put a blanket ban on me. You've got to at least let me, argue my case. So it'll be interesting to see what happens there. But yeah, like I say, people say, oh, why are you always picking on Freeman-on-the-Land? I suppose in a lot of the ways it's a bit like, to scientists they have the things with flat earthers where they just either, dismiss them or just refuse to engage. And similarly, with all my archaeology friends, there's a lot of pseudo-archaeology out there. There's quite a lot of big rows, because people make a lot of money writing all these books. Egypt, 90% of their income, tourist income, is apparently people, read like Graham Hancock books and just want to come in and see all these spooky mysteries of the pyramids and why the Sphinx is actually 15,000 years old. And part of the problem there is they put a lot of block on proper research, because if they demystify, they lose all that tourist income. But when it comes to legal stuff, like I say, if people just want to go and argue a parking fine into a jail sentence, that's on them. But we've seen so many stories of people losing their kids, people losing their houses unnecessarily, because they may have had a case that had underlying merit, but it never got heard. Initially the courts were quite sympathetic and they go, okay, let's forget how you've actually pleaded this, let's have a read into it and see if you've actually got a point. But now, because of the disruption to courts, the disruption to court time, the hassle in the court office, now they are just saying, it's up to you. If you want to choose to run stupid arguments like this, then you must face the consequences. There is, this rather weird thing that with litigants in person, although we are told as barristers we have special guidance for dealing with litigants in person to make sure we don't take advantage of them, But when it comes to the court proceedings, there is a case, Barton and Wright-Hassel being the name of the solicitors, which I think is a great name, that says no, litigants in person are held to the same standards as professionals, and we don't give them any indulgences for getting things wrong. Now in practice judges do actually, when it's just procedural stuff, people use the wrong form or get confused about exactly how to plead things. Judges actually will be very helpful there. If they can see that this is somebody with a genuine case who just doesn't know what to do, then judges actually are very helpful and they will lean on us. And I always do it anyway. I will always send people and say, look, obviously I can't give you any legal advice, but here's the relevant bit of the CPR, here's the relevant practice direction, here's an article that I think explains the procedure very well. Because apart from anything else, I was going back to my sort of the best way to win a case is to help the judge. Sometimes that can involve helping the other party. I mean, the number of times that I've advised clients when they've been up against unrepresented people and said, okay, say to them, here's the deal, go out, find a lawyer, solicitor of your choice to advise you on this, and we'll pay their bill for the legal advice. Because sometimes, that's the best thing that can happen. Somebody on the other side having proper legal advice, because any competent lawyer will say this is not worth pursuing. But I'll say it's your choice. You choose somebody you trust, and I'll advise my client and tell them to pick up the tab. But generally speaking, yeah, there is no sort of indulgence for litigants in person. And that's why I think cases like this, and the risk of getting sued myself, because this guy does seem quite litigious. So I'll just say, in my opinion, based on how they are working, I think their system does take advantage of vulnerable people. Because obviously, some of this was just people going, they'd already paid their mortgages off and they just thought, might be able to get my money back. But this was also people just like struggling with mortgage payments. And I've done enough possession hearings from both sides to know that lenders, generally speaking, they don't want to repossess your property. It's a nightmare repossessing the property because, they'll stick it in an auction, they probably won't get back, as much as they actually need. Now, and while theoretically they can chase the borrower for the balance, it's just not worth the hassle. So I would always advise, if you are stuck, with your mortgages or your rent or something like that, cooperate with the other side, whether it's the landlord or the lender. But then if it does go to court, just go to court and say, look, I've been trying to work a deal out here. And just to let you know, the test actually that courts apply when it comes to arrears and things is there a realistic prospect of paying off the outstanding sum in a reasonable time? And that's, depending on the amount, that's usually at least 12 months. So if you are in arrears and you can work out and say, look, if I pay an extra 30 quid a month, this will clear it off in like a year's time. Courts tends to, be very open to those sorts of offers. But there you go, yeah, so more Freeman-on-the-Land shenanigans. As always, hope you found that vaguely useful, vaguely interesting. If you did, please consider liking, sharing, subscribing, all that sort of thing. And where am I today? I'm actually just back up at Tresillian, because I just really, really like this pub. They do really, really nice coffee. This isn't a sponsored link, I hasten to say, although these coffees are rather nice. But I do like that they put them in very posh, like beaker cups, even though that usually means they're too hot to drink for the first 20 minutes.
I forgot to mention the great pub is the Wheel Inn. So there you go. It's at Tresillian. It's just off the main road, which you can probably hear, but it's a lot quieter around the back.